everyone. Here we are for Chapter 10, Corporate Management. In this chapter, we're going to discuss, now that the corporation's been formed, we're going to cover how is it managed, who plays what roles, who has what responsibilities, and also what privileges come along with some of those roles. So, just to recap, a shareholder, also known as a stockholder, has a financial interest in the company, has bought a share, has bought a stock or multiple, and has some ownership interest in the corporation. Shareholders or stockholders do not directly participate in the management of a corporation. They have indirect participation in management in the sense that they vote on a board of directors who then designates officers who actually run the company. So it's a couple steps removed. Shareholders are, by and large, just by virtue of being a shareholder, you do not go in and tell Bill Gates how to run Microsoft. So shareholders typically are invited to participate in they have the right to be informed of what is going on, the affairs of the corporation, and they vote typically through an annual meeting, or sometimes there are special meetings in which they vote on electing directors, removing directors, maybe if there's going to be structural changes in the corporation such as maybe there might be votes perhaps to absorb another business, things of that nature. So typically the only responsibility, though, of a shareholder is to pay for the shares, pay for the stocks that are issued, and generally there's no liability for a shareholder to pay for any obligations of the corporation. I say generally because obviously if a shareholder were also to play other roles within the corporation, that person might, down the line, kind of when we talk about piercing the veil, that person could potentially be responsible for obligations of the corporation. But if we're just going to talk about shareholders broadly, the way that you and I could be a shareholder in a corporation, we are not responsible for any of the corporation's obligations. Certainly we hope the corporation does well and makes money so that we can then also make money. I do want to apologize if you can hear the noise behind me, but my husband is downstairs watching the draft. He's very excited for there to be any sort of sports on, anything sports adjacent, and so he has the surround sound on. So did my best to get as far away as possible, but I can feel it reverberating, so I'm concerned you might hear some of it. I'll do my best. Shareholders generally have, the voting rates are categorized as straight voting or cumulative voting. Straight voting is just you have one vote for each share. That's the default. It's called statutory voting as well. Cumulative voting is a method of voting when electing directors in which, so if you have a share, you can vote for as many directors as are being elected. So if you have one share, you might get 3 votes because you get to vote for each of the 3 spots that have to be filled. That would be cumulative voting. But it's not that you're getting 3 times the amount of say, you're just voting for 3 different people rather than having to just pick one. If you've ever voted in a local election where you can sometimes choose, more than one person for, like, say, commissioner, county commissioner, it's kind of similar to that. Typically, cumulative voting is only for board of directors, like I said, not other matters that the corporation engages in. And so this is generally provided for either in a state statute or it will be set forth in the Articles of Incorporation. As I mentioned, there should be a yearly meeting for shareholders, but sometimes there are also special meetings. So these are held between the annual meetings because maybe there is something that has come up that needs to be discussed or voted on, or maybe some directors have left. Could be for innocuous reasons, maybe it could be for more serious reasons, but if you need to fill directors, a special meeting might be held in order to do so. Special meetings, though, are generally called, when they're held, they're called by the board of directors. Um, there is also the possibility that, if it's something where shareholders are having an issue with the company is doing, shareholders can also band together and call a special meeting. It's typically only shareholders who own more than 10% of outstanding stock who are able to call the special meeting. Now, when a meeting is to be held, notice has to be given to all shareholders that are entitled to participate. And if you look on page 153 of your book, they give you an example of what it would look like for a notice of annual meeting of shareholders. And this is set forth by state statute. So depending on which jurisdiction you may be working, and if you're responsible for organizing and sending out notice for an annual meeting, you're going to want to make sure you abide by the statutory requirements for how the notice should be written and how it should be given, and make sure that all shareholders are notified appropriately so they have the right to participate. Typically there's like a time frame that says you can't send the notice out, you can't issue notice too far in advance, but it also, there has to be no more than 45 days before the meeting and no less than 30, things of that nature. So once the meeting is called to order, the first line of business, I suppose, is to see if there's a quorum. And a quorum is the minimum number of shareholders or directors required to be present before an action can be taken. Generally, it's just a majority of shareholders or the shares represented, essentially. So it might be two people who own 75%, and if they're there, it doesn't matter how many other people are there because we have a majority of the shares represented. But if there is no quorum, typically the meeting is adjourned and would have to be rescheduled in order to make sure that there is a quorum. Because typically actions cannot be voted on and taken if there is no quorum, if there's not enough people. Sometimes in order to get a quorum for voting purposes, proxies can be issued, and a proxy is just to say, listen, it's a written authorization. I can't be there. I can't vote in person, but I'd like to make sure that Jeff Smith has my vote and he can vote on my behalf or on the behalf of my shares that I own. So that is one way in which to encourage voting, whereas some people may not be able to attend, but they can complete a proxy at a time. So during the meeting, when it's let me just cover that. So like I said, proxy is just a written authorization, and the person who has been given the right to act on the behalf of another is the proxy holder. So during a meeting, there are a lot of times there will be resolutions presented. I should just go back for 1 second. During the meeting, minutes will be kept of everything that goes on, and that's really important. As we talked about when forming the corporation, one of the supplies that the corporation needs to have is, minute books. how are these records going to be kept of what happens? So typically somebody will be designated to take the minutes. Nowadays, things are recorded. I know that I sit on a board for a nonprofit organization and I'm the secretary. I take notes during the meeting, but it's also held via Zoom. And so I get a copy of the recording after it's done. So I can go back and I can double check my notes, make sure I didn't miss anything. And it's just a really nice way to be able to make sure that the minutes accurately reflect what happened. I present those to the executive director, and the executive director within the organization, which is a corporation, maintains those records. So, you may serve in a role to be taking minutes. It's very possible. That is one possibility if you are working for a corporation, or maybe not in-house, but a firm that has helped organize an organization and would continue to serve in its business affairs. So, but in any event, somebody has to take those minutes. Somebody has to document what happens. Are there motions that are presented? Are there resolutions that are presented to the board? How are they voted on? And voting can typically happen in two ways. There's majority voting, which is just easy, which is, 51% or more. And then there's plurality voting, which is sometimes we don't have, especially for electing directors, we may not, no one person may get 51%. They may not get a majority. But plurality means that the candidate who gets the most votes out of the percentages, which are in theory less than 50, wins. So for example, if candidates Amy, Bob, and Cole receive 45, 30, and 25% of the votes respectively, so that adds up to 100%, then Amy has won by a plurality because she had the most of those percentages. None of them won by majority vote, but Amy won the most percentage of the votes, so the most number of the votes. So a lot of times, if a majority cannot be reached, then sometimes boards will say, well, let's vote, under a plurality. But a lot of times it's just with respect to election of directors. So that will take place at a meeting. There is an example in your book on page 156 of the minutes of a meeting. Now, this is just an example because I will tell you that, having been a part of different organizations throughout the years, meeting minutes are done in very different ways. Certainly, if it's a new organization that you are working with, you may create the minutes from scratch and that may be the template that they go with moving forward. But, if you're coming into an organization that's already been established, you're going to want to look at old minutes and see, well, how are they drafted? I know for myself, when I draft minutes, I take an old version, I highlight the whole thing, I change, and then I go through each section and I change all of the information. I take out any things that were different from the last one. But just like with anything, if there's a template, there is no reason to reinvent the wheel. I think it's an inefficient use of our time. We have enough to do in this field that we don't need to create more work for ourselves. So that's a recommendation I have there. Now, there are a few shareholder actions which can take place without a meeting. One is considered a direct action and the other is a derivative action. So a direct action is essentially litigation. It can also be called an individual action, and these occur when shareholders are disgruntled. They feel like the corporation is doing something wrong or depriving them of something, and so they want to take some sort of action. In a direct action, the individual is saying, I am personally being harmed. This is a direct harm to me. Like, you're not paying out dividends, and so I'm being deprived of my financial interest because you are not paying out interest or dividends that I'm entitled to. And so that would be a direct action that a shareholder can bring against the company. A derivative action is one in which it's basically like an order to compel. So this is an action filed against the corporation to enforce a right, to say, I want the corporation to have to remove a director who's behaving badly, or pay dividends that aren't being paid. So those are the differences there. Shareholder actions of this nature are not frequent, I guess I would say. Unfortunately, they do happen, but it is not the norm. Again, if a corporation is doing everything that it's supposed to do, then we shouldn't have to see any of these. But, this is really kind of when everything else has broken down and the shareholder feels that he or she has no choice left but to sue the company. Okay. We have talked, I think, probably ad nauseum at this point about the fact that one hallmark of a corporation is that the owners, shareholders, are not personally liable for any wrongs or obligations that the corporation has. So, that is the general rule. There is an exception to that under the doctrine of piercing the corporate veil. Again, this is one of those things where it doesn't happen a lot, but it can happen under certain limited circumstances. So times in which this does happen is if the company is commingling assets, if the company is not really operating in a formal way that it should as a corporation, or if it is inadequately capitalized, meaning it does not have enough money to meet its responsibilities, then a court could essentially look at the corporation and say, you're really not behaving as a corporation because you're not truly abiding by the rules to operate in this way. You don't get to take advantage of the benefits of that shield, basically, that veil that protects the individual shareholder's personal assets. So the purpose of when the corporate veil is pierced, it is done so to prevent fraud and injustice that is occurring. It's, in theory, courts have this broad power to do this when they feel that there has been a fraud or an injustice. But in reality, it's really not done that often. Basically, courts are only doing this when it appears that someone has just kind of created like a shell corporation, for lack of a better term. I mean, when it's just someone created a corporation to just shield their assets. So the commingling of assets is easy to see, because if Joe Smith has formed Smith Incorporated and all of the business money goes into his personal account with his wife, well, that's not keeping corporate assets separate. He is clearly commingling that with his business, and that is not permissible. The business should run like a business. Joe can pay himself. He can pay himself a salary, and that can go into his personal account. That's fine. But he cannot basically just say, well, it's just easier this way. Well, you know what? A lot of attorneys would probably say, it's just easier to just throw the client's money all in one account. But a lot of lawyers lose their licenses either permanently or at least temporarily when they commingle the assets of their clients with firm assets. And just like in the law, that is not permissible in the corporate realm as well. So if the funds are commingled, courts will look at that and basically say you're not operating as a true corporation. You're supposed to be a separate legal entity, a separate person. And if you're not behaving in that way, we're Joe Smith in this scenario, you're personally responsible because you don't have a distinct separate business from what we can tell. When we talk about lack of formalities, this is if the company is, not issuing stock, not having meetings, doesn't have a board of directors. So no board, no officers running things. If it's just not really operating, let's say all it's done is just incorporate and then hasn't done anything else, that's going to be seen as essentially just, an alter ego of the owner or the owners. And like I said, with inadequate capitalization, some courts will say that the corporation has to be grossly inadequately capitalized. So it just really, really has to be very drastic. Not that there really should be a distinction between a company that maybe has lost money and doesn't have assets versus one that has just never put enough money into the corporation as well. Again, really is just kind of a shell and doesn't have any substance to it as well. So those are common situations in really the three most common situations in which the corporate veil is pierced. Okay, sorry. So once the corporation is formed, there will be a vote to, as we talked about before at the initial meeting, there will be a vote to elect directors to the board of directors. We typically want to stagger them from the outset. So if, let's say there's going to be 7, you want 3 to have a 1-year term, 4 to have a 2-year term, and then from then on, you won't be turning over the board all at the same time. And it doesn't have to be just necessarily with those numbers, but that's just an example. So what do directors do? What do the folks on a board for a corporation do? Well, they vote to authorize distributions. They might be responsible for adopting, amending, and repealing bylaws. So remember, when we have that initial meeting, we vote on the directors, and then the directors then adopt the bylaws. Directors also appoint, supervise, and remove officers. Now, directors are not managing the day-to-day affairs of the business, but they're kind of these overseers, these gatekeepers who get involved on big things. Again, for the organization I serve on, I spend a couple hours a month doing stuff for this organization. And probably that might be more than, say, some of the other folks on my board. Now, I'm on the executive finance committee because I am the secretary, so I do have to take the minutes. But if I was just serving as a general board member, I might only spend an hour and a half a month when I would have to attend a board meeting. And that's it. Reviewing the minutes ahead of time, something like that. So directors are not involved in the day-to-day affairs. But when it comes to the big things like, hiring the CEO or approving or allowing, let's say, the CFO or an executive director to take out a loan or give out loans, whatever it might be, depending on the nature of the corporation, those types of big picture decisions are often decided on by directors. So, are we going to issue stock? What's going to be the price? Are we going to reacquire stock? Are we going to take out loans? Are we going to issue bonds? What are we going to do? Those large scale decisions are voted on by the directors. Is the company going to sell items, and what's going to be the cost? Determining wages and employee benefits and compensation, that is something that directors may do. That is not necessarily in every field, I will say, but that is something that, depending on the corporation, that might be. I know that, I have previously voted on whether certain folks were entitled to raises. And again, that's, as a director, I never felt like that was really my say. But if you have the person who's running the company saying, listen, I think that these folks are entitled to a raise, and presenting a really strong argument on it, it was a no-brainer. Again, I'm involved in a small enough organization that I can see the work product of those folks who were entitled to the raises. So it made complete sense, but it was something that, I've had no say in determining their wages otherwise, or what benefits or anything like that. But that was one instance in which the board was called in to decide on that. Directors, again, may be asked to vote on really big matters like mergers, acquisitions, that sort of thing. Purchasing or selling corporate assets like buildings, other property. And directors are expected to operate and exercise a duty of good faith and due care. So they are not supposed to engage in a way that is beneficial to themselves and must act in the best interest of the corporation. I know that most organizations will require directors to fill out statements if there's any sort of conflict of interest of any kind. And assuming that there is a conflict of interest, sometimes they will have to sit out certain votes. They don't have to resign off the board altogether, but again, depending on the nature of the organization, some directors might say, you know what, I think it would be too much of a conflict if I voted on this issue. Excuse me for 1 second, I have to let my cat in. Okay, sorry about that. All corporations have to have a board of directors. There must be at least one, obviously. Some states require more than 3, but again, state by state, see if there are specifics in, how many there can be. Directors should hold annual meetings at the very least, and they may decide that they have to hold other meetings, at different intervals, at other regular intervals, I should say, depending on the nature of the business. If there's going to be a special meeting, again, there needs to be appropriate notice that is given out so that all directors are notified that they can attend. In between meetings, they sometimes will send out, written consents or resolutions that can be signed by all directors. So it's essentially voting on an issue, but not meeting to vote on it. I do want to point out that in general, directors are not personally liable if they make an error in judgment. Okay, so as long as they are exercising good faith and due care in making a business judgment, they are protected from personal responsibility or personal liability. If they are grossly negligent and anything beyond that, intentional in their poor judgment, then they could be personally liable. But we do want to try to shield we presume that directors have acted in good faith. There is that presumption there. So to hold a director liable, we would have to show gross negligence, recklessness, willful abuse, willful disregard of the company's interests. Really has to be egregious conduct to hold a director or an officer personally responsibility. And I know that a lot of corporations will also secure directors and officers insurance, which is just um, an added level of security in having them feel confident that they can make decisions without being personally sued. Because I will tell you this, I volunteer my time to sit on a board for an organization. If we authorize an action to be taken and it does not go well for the business, but we thought it sounded like a reasonable business decision at the time, I certainly don't want to be sued and have someone trying to seize my house because they were harmed by the outcome of that decision. As long as we're acting in good faith at the time, we are protected. But again, this is really where it's very important to disclose a conflict of interest. They arise. It's not the end of the world, but directors need to know that they have to disclose that conflict of interest or it looks really bad. It just was like, first thing that came to mind, and it is not exactly the same thing, but the first thing I just thought of was a couple of Congress people who recently were certainly privy to information about kind of what was coming down the pipeline with the COVID pandemic and probably could anticipate that stocks were going to be affected when governments and businesses were going to shut down, and they unloaded a couple $1 million of stocks each so as not to have their portfolios take a hit. That's a conflict of interest. That's not the same exact thing here, but it certainly is. You can see where that conflict is. It's like, wait a minute, you really should have. That just seems like immoral and unethical, in my opinion. It's kind of like if it doesn't pass the smell test, so to speak, there's an issue there. So directors should also feel empowered and authorized to consult with experts. So if they're not sure about something, maybe it's like a marketing issue, talk to a marketing expert, rely on others, or delegate authority amongst each other to say, oh, you have more skill and judgment on this. Like, what do you think? Can you look into this? This is something that you might have a better idea about. That's wise because that's looking out for the best interests of the company. So those types of actions are permissible. Now, when we talk about corporations, we talk about all of these rules in place as to how we want them to behave properly and not violate any rules or laws. But unfortunately, there have been significant scandals in the past. And the suspected causes of corporate scandals, kind of like in general, are excessive compensation given to corporate managers. So, just unbelievable amounts of money paid to folks who are running businesses. Sometimes when I hear about these figures of what people are paid, it's kind of unbelievable. But if there's a lack of accounting oversight, that can also lead to kind of egregious and inappropriate behavior. So I'll kind of I was going to jump around a little bit, but yeah, we'll talk about euphoria and hype and then regulatory oversight and greed in a moment. But there have been provisions put in place which attempt to prevent more egregious behavior that leads to scandal. And as a result of the collapse of Enron and in the early 2000s, a number of corporate scandals, the Sarbanes-Oxley Act was enacted after Enron in order to try to create some more oversight and regulation on corporations with the hope of preventing future scandals of that significant nature. So some of the ways in which they did that were to have an oversight board. And basically another set of eyes to make sure that corporations were behaving appropriately, to establish standards, to say, your accounting should be done in a certain way and reporting should be done in a certain way, to conduct investigations when there are issues regarding possible violations, to increase penalties for securities fraud. And so to have independent auditors who could take a look at the books and the accounting for companies suspected of any violations. We want auditors to be independent because obviously they should just be going in with no agenda of any kind and looking at the books of a corporation. But Sarbanes-Oxley really tried to just, more than anything, it just tried to produce oversight on corporations who are not ripe, suspected of or have the potential for abuse. And really, it's supposed to also scare corporations enough to say, hey, don't engage in this behavior because the sanctions are broader and the SEC, the Securities and Exchange Committee, have more power, essentially, under Sarbanes-Oxley. So it was meant to be a deterrent to corporations who were inclined to cook the books or mishandle money, things of that nature. There are also, there's been a trend to, have governance guidelines within corporations. So internally, a lot of them have adopted certain guidelines to say, we're going to try to clean house from within. They try to, there's been a desire to have more diversity within the board of directors. So people from maybe different areas, different fields, folks who may not all have the same type of interests, so that there is just what's seen as more independence. People who are truly independent in the sense that they don't have any financial interest in what the company is doing. They're not shareholders. They don't have a buy-in. So, one outlook on that is they're not really out for themselves. Sometimes it's thought, well, if you have someone who has a buy-in, they have an incentive to want to see the company do well. So there's some argument both ways there. Some of the largest scandals have been associated with the top executives getting huge payouts or finding out that they were getting these huge salaries when the companies were doing terribly. So obviously there's something wrong there. If a company is faltering. Why should the top executive be making oodles and oodles of money if the company's not doing well and everybody else is suffering or the shareholders are suffering? So it doesn't make a lot of sense. So one kind of internal governance guideline has been to link executive pay to company performance, which should make sense. If the company does well, then the executive can make more money. It's an incentive to do the right thing and help generate profits rather than just being paid a large sum regardless of how the company actually performs. Some corporations are requiring periodic audits and reviews of the operations. So they might have a company that comes in just to make sure, are all the meetings being held? Are the minutes being kept? Are actions being taken appropriately? Are people voting the way they're supposed to? And like I said, some do require that directors have some sort of stock ownership. They kind of want them to be financially invested and have an ownership interest in the company. Again, that's not all corporations, but I think there's some valid argument there that if you can benefit financially from the corporation doing well, you might be more inclined to vote in favor of the corporation doing something that could be profitable. So that makes sense in that respect. Now, another piece of legislation that was enacted following corporate scandal was the Dodd-Frank Act. And this came about just want to get the year, this was in 2010. So this was after the 2008, I guess in 2009 reception after Bear Stearns collapse. And, I know that was the first time I had ever heard about, these mortgage products that were being sold. People were just buying mortgages that they couldn't afford, and it was really devastating to the economy. We eventually rebounded, but it was really, really shook things up for a while for those of you who recall that. So, obviously, there was a lot of controversy over the government bailing out big businesses when this occurred, but it was in an effort to try to get the economy back on track. So one of the things that came out of that was the Dodd-Frank Act, which said that, okay, that's fine, to these corporations, to large publicly traded companies, we are going to impose restrictions or regulations concerning corporate compensation and governance. And so the Dodd-Frank Act imposed independent compensation committees. So any company listed on any of the national stock exchanges are required to they have to have compensation committees who are comprised of only independent directors, meaning they cannot have any sort of personal or familial connection to the corporation. And any advisors that the committee has also have to be truly independent. And so they then look and determine who should be paid what. There's also the concept of say on pay and frequency votes. And this is where companies must provide shareholders with non-binding votes on executive compensation for certain executives at least once every 3 years. And basically what it does is it allows shareholders a right to have a say, and it's non-binding in the sense that the company could say, all right, well, we know that you only want to pay the CEO $200,000, but we're actually going to pay the CEO $1 million. Now, it's non-binding, but it does give uh, it does give the shareholders some say, and because if the officers are going against the directors, um, or going against the shareholders can then vote those folks out. So can vote the directors out, and perhaps get rid of some of the officers in that respect as well. So it gives the shareholders a little bit of a say. It's kind of like being a voter and saying, well, I'm not really happy with the way things are going in politics. Okay, well, we elect the politicians. If we don't like what they're doing, we can, in theory, vote them out. Kind of similar in that sense. The Dodd-Frank Act also required companies to disclose what we call golden parachute situations. So this is when a company is failing or somebody is being ousted from a company, but top executives are being paid huge sums of money on their way out. And we've seen this in the financial sector. We've also seen this. First one that comes to mind is the guy who ran CBS. I think it's Les Moonves. He was accused of inappropriate sexual behavior with employees and such, and CBS got rid of him, but he, per his contract, got a huge payout on his way out. So that was, part of his deal, but certainly something that was subsequently disclosed and known in the news. The Dodd-Frank Act also set forth a disclosure format for compensation. So what it does is it basically provides like charts or ratios of showing how the executives are being compensated versus their performance, the financial performance of the company. So they have to put together these charts so that somebody could look at it and say, well, wait a minute, this is this isn't squaring. Why are these people getting raises and getting paid so much money if the company is not doing well? So it's a way to see that, from an outsider perspective. And then finally, the Dodd-Frank Act also allows for clawbacks. I guess the most common, a clawback is basically when if it turns out that an executive was like improperly paid or paid based on erroneous information or, maybe fraudulent information, that sort of thing, then the government can require that the company claw that back. The most common one I think of when I think of this is with Wells Fargo, when it was discovered that Wells Fargo employees were creating new accounts in the names of existing account holders. These account holders had not authorized these new accounts to be issued. And so what it was doing was looking at the company was like really busy and just generating a lot of volume. And the Wells Fargo was punished by the federal government for this behavior, but also the federal government took back money that had been paid to at least one top executive, kind of on that person's way out. And so the government was like, absolutely not. Like, this was such inappropriate behavior, really, from the top down. And they were able to establish that it was from the top down and not just like a local branch thing. So they were able to require that this money be pulled back. There have probably been others, but it's definitely the most common one that I know of. So those are some efforts that have been initiated in order to, what we hope will curb inappropriate behavior by corporations. Now, like I said before, Directors are appointed or elected, by shareholders. And then once the directors are in place, they appoint the officers for a corporation. The kind of main categories, the titles that we hear are like president, vice president, secretary, treasurer. Sometimes we hear chair, vice chair, chief executive officer, chief financial officer, chief operations officer. There was chief information officer, I think was the one I heard recently that was very interesting to me. Chief marketing officer. We depends on the nature of the business as to what the title may be. A corporation does not have to have all of these officers. It can have less if it wants. It depends on the needs of the business. But it should have enough officers in order to carry out the day-to-day affairs, because that's what the officers do. They are the ones who, run the business on a day-to-day basis. Officers have certain fiduciary duties to the company, and they have to make sure that they are acting in the best interest of the company. Because when they act, they are acting on the behalf of the company. They have authority to act on behalf of the company. And so they, in order to protect themselves, they want to make sure that they're behaving appropriately. But they can be removed by a board, generally, unless there is a contractual agreement that says that, they have a term for a specified amount of time, and can only be removed for certain reasons. Well, okay, if they have an agreement that states that, obviously those parameters would have to be followed in order to remove them. But if there is no such agreement, then an officer can be removed at any time pursuant to a vote of the directors. And again, it's good practice for a corporation to have directors and officers insurance so that both sets of individuals have their personal assets protected. So just to recap, kind of the three main groups of people are shareholders, the owners, directors, kind of the overseers, and the officers, the day-to-day managers. Shareholders own, but they don't manage, and basically all they do is indirectly participate by voting. And they do so usually at annual meetings and special meetings. If they feel that they have been wronged, they can bring a direct action or a derivative action. Shareholders could be potentially personally liable under the concept of piercing the corporate veil, but that is only if really there is no true corporation. And in fact, it really is just an alter ego of the shareholders. Directors are voted and elected by shareholders, and they meet either at least annually or regularly and may have special meetings. They can also vote on things in between. They have fiduciary duties. They are presumed to act in good faith and for a reasonable business purpose. If they did not, and we can prove that, then they can be personally responsible. So that is chapter 10. I will cover for you chapter 11, chapter 12, and chapter 14. And that will be next week. And then that will finish off the semester. And the only thing after that will be the final due the first week of May. So I hope that you all are doing well. I wish you all the best. And let me know if you need anything. Take care, everybody. Good night.